Well, welcome back to another Cordell and Cordell virtual town hall. I'm Scott Trout, CEO and managing partner of Cordell and Cordell. As you know, we continue to bring you information for guys before, during, and after divorce and everything related to family law. And today is no different. We're joined by a panel of Cordell and Cordell attorneys, and we're going to talk about the divorce process and really investigating it and what you should do to prepare yourself for it. We'll continue to give you tips, educational things that you can, talking points you can take to your attorney when you have a consult, or many of you that are watching and listening right now already have an attorney. We want to give you some ideas to stir a conversation, to really progress your case. And this really is about guys who, during COVID and thought about divorce, they want to know what I should be doing to prepare myself, things I should expect. And that's what we're going to be talking about today in investigating the process. Speaking of consultations, as always, we're available for a consultation if you need one. You can go to the web and find us at cordellcordell.com, or you can go ahead and give us a call at 866-DADS-LAW. We're available via Zoom for a consultation or by telephone. We also are available in certain areas around the country. As you know, we have offices throughout the United States and in the UK, but health, safety is a priority for us. So give us a call, 866-DADS-LAW. We'll give you information and give you the options available to you to speak with one of our attorneys. And as always, and I start my podcast, to make sure you don't substitute this virtual town hall for a consultation with an attorney where you can actually get legal advice. Keep in mind, this shouldn't establish in your mind an attorney-client relationship. And again, don't take this as legal advice to your case. Your facts, your circumstances are particular and peculiar to your case. And oftentimes the things we talk about today and perhaps the educational and talking points we provide would be entirely different if we had you in that hour. It really is the best use of your time to spend that hour with an attorney to get a consultation. At the second half, or in the second part of our virtual town hall, as we do each month, we'll be doing a lightning round where you can submit questions via the Q&A section. So take a look at your Q&A section using Zoom. Go ahead and submit a question. And in that second part of our conversation today, we'll be able to provide answers from our panel of attorneys. So go ahead and submit your question using your name, first name only, and the state, so that we can provide to you that question to an attorney that has coverage in your state. We'll do that today. So otherwise, if you don't want to submit a question today to get answers today during our virtual town hall, you can submit those via email at coronavirus.divorce@cordelllaw.com. Every week, twice a week, we have a podcast. We'll devote one of those to answering questions that are submitted to coronavirus.divorce@cordelllaw.com. So before we get into the topic for today, we want to introduce our panel of attorneys that are joining us. First, from Peoria, Arizona, Jessica America. Welcome.
Thank you, Scott. Hello, everyone. As Scott mentioned, my name is Jessica America, and I work out of the Peoria, Arizona office. But I have clients across the valley at all 4 of our locations in Maricopa County, and also clients outside of Maricopa County. So we actually service all counties in Arizona. I've been practicing family law for 5 years in Arizona, and I currently work for the best civil or family law litigation firm in the world. So thank you, Scott, for having me.
Thanks, Jessica. Next, joining us again with our virtual town hall in New Jersey, Diana Magala. Welcome.
Thank you. Good afternoon, everybody. My name is Diana Magala, and I have been practicing family law for almost a decade. I am duly licensed in New York and New Jersey, and I actually handle cases in both offices in our New Jersey and New York locations. I've been with the firm for almost 6.5 years, and in my time here, I've been nominated for New Jersey Super Lawyers for 3 years in a row. Thank you.
Thanks, Diana. Again, joining us in our virtual town hall from Texas, Colleen Kinsler. Welcome.
Thanks, Scott. I'm so happy to be part of today's town hall. So I have been a family law attorney for about 12 years at this point. I'm licensed in both Illinois and Texas, but currently practicing in Austin, Texas. Our Austin office handles almost the whole Central Texas area. So we look forward to helping all the dads out there. Thanks.
Great. Thanks, Colleen. And rounding out our panel for today, joining us again in our virtual town hall is a repeat guest from Miami, Florida, Allison Morris.
Hi, Scott. Hi, everybody. Thanks for having me today. I'm the litigation manager in the Miami office. I've practiced all of the state of Florida. I've been with the firm for almost 10 years now, and I've been Florida's Super Lawyers Rising Star a number of past years.
Thanks, Allison. Again, don't forget to submit your questions if you want them answered via the Q&A section in your Zoom. You can click that button and submit your question. Again, first name and the state. Don't bother with your last name. We want to keep anonymity as much as possible. Before we get into investigating divorce, getting you some tips, getting you some advice in terms of what to expect, not on your case, but what you should be expecting in terms of a strategy. We'll get to that in just a second, but first, we're going to get to a quick commercial break and we'll be right back.
For some dads out there, the coronavirus pandemic has become a pretext to limit access to their children. Other dads have been pushed out of key decisions affecting their children's lives. If you're one of those dads, Cordell Cordell is here for you, as always, but with expanded services. We can meet you in person or by video conference on weekdays, evenings, or weekends. Our goal is to step up our service to meet your needs now.
Welcome back. Let's get right into it again. As I continue to remind you, submit your questions via the Q&A section so we can get to those in the second part of our town hall. You have that opportunity to ask questions live and get answers from our panel today. So Q&A section, make sure to take care of that. Otherwise, you can submit them at coronavirus.divorce@cordelllaw.com. All right, Diana, let's get to it. Let's talk a little bit about the process of divorce. And I've often talked about titles. I've often talked about filing first, but really as guys are considering divorce, when they're thinking through it, does the title really matter? Whether it's plaintiff, defendant, petitioner, respondent, we see those titles. Does it matter for guys?
Luckily, it doesn't matter. I mean, it's always obviously smart to file first for several reasons, but if we're just going to talk about title, luckily we're not in criminal court, so there's no negative connotation in being the defendant. So don't despair if you're the defendant, that's okay. In every court, as a defendant, you are allowed to file an answer and a counterclaim and proceed just as a plaintiff would. It's just about preparation, but as far as title, defendant and plaintiff don't matter.
Yeah, the judge won't look at you differently just because you've got defendant next to your name, right?
Correct. Not at all.
Yeah, and I've talked about filing first from a strategic standpoint, and I do see some advantages there. And ignoring the title, it's more about positioning rather than title, right?
Correct. So for example, if there is maybe debt that's been accruing or marital assets, you want to cut off the date of the marriage. So you want it to cut off. And if you file first, obviously you have that upper hand. Same thing if custody is in dispute. But again, if we're just talking about, well, she filed and now I'm defendant, am I in trouble? No, absolutely not. Let's just proceed and keep going.
So when guys come in for a consultation, Diana, a lot of times I start it when I say, look, think about the most negative things that your wife is going to say about you. Isn't that a good place to start and kind of talk through a little bit of that?
That's what I always say to my clients. So they say, what should I expect? And I tell them, you know best. Tell me, think about the last 6 months where it's been really, really bad. And what has your wife been saying about you? And that's really going to be, let's say, for example, custody, right? She's saying, well, you never feed the kids. That's probably something that I'm going to hear about in court, her saying he's never made a meal for those kids. Think about everything negative she said when you guys are fighting and really take that to heart and say it to me. There's nobody that's going to know other than you. And don't be embarrassed. I mean, this is what it is. Unfortunately, people are going to not be the nicest to each other, but there's no way of me finding out. And don't let me find out in court. Tell me before. Don't be embarrassed. Tell me this is what my wife has been saying. And really the reason for that is I want us to get ahead of it. So for example, lots of times, mom will say, well, we'll use the example of he doesn't feed the kids. 9 times out of 10, my clients will have text messages showing, hey, I've made this meal for the kids, so-and-so loved the meal. So if you tell me what it is, we can find ways to get ahead of it before I have to hear it in court.
Yeah. I always do. I talk to clients and I said, look, I've been doing this for, 27 years now, and I've heard it all. I really think I have. I mean, I've been doing it for so long, and not to be embarrassed, because that is part of the problem with family law is guys, it's sensitive. The information they provide, it can be embarrassing. You know, the events in their life, the moments, whether it's emails or recorded conversations or videos or photos. The point is, as you suggest, Diana, which I think is a great one, is we want to be prepared for that. And there really isn't a situation that in my career where I've been unable to formulate a good strategy, you know, taking child abuse out of that situation or neglect, right? But some of the things that can tend to be embarrassing and, you know, your worst moments in life, fine, we'll deal with it. Judges have heard it as well. They've been on the bench likely forever. And so I think, you know, that's a really good piece of advice. And if you ever watched my 10 Stupidest Mistakes seminar or read the book, the point is that you treat this relationship much like a doctor-patient, and that is be direct, be honest, just like you would your doctor because you want to be healed. Well, you want to give all the bad information to Diana and the rest of our panel because you want us to formulate a strategy to get you in the best position possible, and that's why we're talking about it today, to successfully either prosecute or defend your case. So that's a good point. And let's talk about kind of the things that, you know, thinking about in that conversation where you're asking for the negative things, asking them to prepare things or to get things. Should they be looking for and bringing in emails and text messages and other items of information that could be helpful?
Yeah, so the reason that we're asking you to tell us this information is, like I said, for example, if she says something about you, it could be a lie. Most of the time it is. It could be a lie. And the best thing that's going to happen is when we file a motion with the court, it's two conflicting certifications, right? She's saying you're the worst person in the world, and you're saying I'm the best person in the world. At the end of the day, the judge is going to hear two conflicting testimonies. Sure, the judge may find a credibility, but if you're both credible and good witnesses, the only thing that will have us succeed is if we have something in writing, if we have a recording, if we have a text message, if we have an email. And that 9 times out of 10 is the smoking gun. Judge, she just said this, but here's a text message from her saying how great of a dad I am.
Yeah.
So that's very, very important. We're not asking you for these documents because we want to look through your text messages and we're being nosy and we're just entertained 9 times out of 10. Again, this is the one thing that will get you that credibility with the judge.
Right. I remember I had a client, 20 years ago, and he handed over a box of evidence and things that were really sensitive and embarrassing. He goes, enjoy it this weekend while you review it. I'm thinking, look, this is about me preparing for your case and making sure we can get what you want done. This is nothing about personal. I'm not going to go through this for our benefit personally, right? And so that brings up the idea of when we ask clients for all the negative things or all the things that we need to know, there's a tool called discovery. We've mentioned that. It's a legal term. It's nothing more than just gathering information and evidence, right?
Correct. So discovery is different documents that opposing counsel will ask for, and it could be financials, it can be text messages, it could be pictures. And sometimes we ask the clients to send us discovery before opposing counsel does as well. And again, these are all in the form of documents, and we would ask the opposing party for the same thing. So somebody that says that, you know, they earn cash and they barely make any money, a form of discovery would say to subpoena all their bank accounts. And if there's cash deposits, that's how we find out.
Yeah, and participating, I think that's huge. You know, the tendency for clients is hire a lawyer, that's why I hired them, you do your job, and they just wait to kind of be instructed or advised. Don't you agree that if there's discovery, documents, evidence, you know, whatever it is, they should participate and review everything because they're going to pick up on something that you wouldn't or I wouldn't, right?
Exactly, absolutely. So there are some things we just simply, as your attorneys, will not know. We won't know if she's hiding money until you tell us. We won't know if she's doing something to the child unless you tell us. Yes, as attorneys, obviously we'll be able to look at the documents and say, what is this? This is showing me something, but you know your case best. And judges say this all the time. We don't want to decide your case because you know your case best. Of course, we'll guide you, but if we send you a document, there's a reason for it. We want you to look through it. And even if it's 100 pages or 200 pages, there's a reason that attorney on the other side sent it to us. It's not because they're trying to bury us in paperwork. They're going to use it against us. So as the client, you have to look at every single document and work with the attorneys. And the same goes for when we ask you for certain documents. Many people think, well, this is not relevant. It has nothing to do with the case. If we're asking for it, it's relevant. And a lot of times people don't realize this, but the courts can dismiss your entire pleading, which means the other person could proceed without you, or just not submitting one certain document, including financials or text messages or affidavits. So every document is very, very important, as tedious as it may be.
And responding timely, right? If we ask for it, get it to us timely. That's a hard thing to take. You know, life is busy as it is. This is stressful. It is one of the most stressful periods other than death and taxes, right, is divorce. And so you would say, hey, if we ask for it, jump on it. There's a reason for it. We're asking for it within an X number of days.
And don't forget to ask us questions. I mean, this is always my favorite question, right? So for the complaints for divorce or our answers and counterclaims in New Jersey, we have to have opposing party social security number. 9 times out of 10, my client just ignores me. And then I'm chasing. And then I'm like, why didn't you just send me this document? Well, I don't have it. Had you just asked me this, look at the tax returns. Have you guys ever filed joint tax returns? Look at the tax returns and you'll find it. But again, just ask us questions and we'll be able to guide you, but only you can get us that information.
And I think, Diana, kind of what you're alluding to is develop a relationship with your attorney as you're selecting one. I've talked about this a long time. As you're interviewing lawyers, you should be looking for one in a similar relationship as your doctor. You want to have that good communication style with them. They should be communicating with you responsively. That's kind of the thing that we have at Cordell Cordell, which is you email us, you call us, you get a call and or an email returned the same day. And so that's, I think, Diana, that's a good point in terms of making sure you communicate and ask the questions. So, you know, Colleen, let me turn to you. We alluded to it with Diana. We talked about discovery, and that's a really important thing when we're investigating the divorce process, whether you filed or not. There's, you know, some things where you want to utilize discovery and you want to collect the evidence. And, you know, as every family law case, it was funny, I was sitting at a baseball game watching someone play last weekend, and I heard this person say, well, you know, family law, it's all the same. It's cookie cutter. Well, I disagree. I mean, I've been doing this for 27 years, and I think that's the unique thing is that every case is different, right? So discovery should be different, Colleen?
Absolutely. That's the biggest thing is every case is absolutely different and your discovery plan should be different as well. Many cases, the need for discovery it's going to be contentious. The discovery is going to be a bunch of discovery having to do with either custody or finances. And some cases might be proceeding a little bit more amicably. And there's ways to focus on that as well. You really don't want to put yourself in a position where you're paying your attorney to go on a wild goose chase that is unnecessary, unjustified, and is just costing you a lot of money. So really talking with your attorney of what the issues are and coming up with a plan and a strategy for your case specifically is incredibly helpful.
Yeah. And so you think about it, I guess it can be expensive, and that's why it's important to have a conversation about, let's talk about what's appropriate for your case. And obviously, the more issues, the more contentious, it means there's more opportunity and more need for discovery, right?
Absolutely. So if you think of, for example, custody cases where alcohol is an issue, for instance, trying to get that evidence, sure, formal discovery, asking someone a question might be helpful, but more than likely you're going to want to use other resources with that to get that information and uncover the truth of, all right, opposing party has a drinking problem. How do we figure that out and get that information in front of the courts? For instance, SoberLink is a resource that can be used where someone has to take a breathalyzer test when they're with the children. These reports get sent back to you, get used in court to show what is that alcohol problem. That's another form of discovery that goes beyond just sending formal documents or asking for documentation. Another thing to look into is a private investigator, for instance. Again, let me use the alcohol as a reference. If you're thinking opposing party is drinking when she's in possession of the children, you can hire a private investigator when it's her weekend with the kids or when she has them, to significantly cheaper than an attorney, to go and keep an eye on her and be able to report back to the court saying, all right, she took the kids to a bar and here's this proof, which is fantastic.
So thinking about ways to be economical. That's why you should have a conversation about what steps the attorney's taking. There's something called an agreement you could reach to exchange documents. I know here in St. Louis County, I'm licensed in Missouri, Illinois, and Georgia, but in particular St. Louis, there's a mandatory document exchange that is in lieu of formal discovery. Is that something that happens in Texas? Isn't that a good idea, or is it a good idea? And what are the the positives and negatives with it?
Absolutely. So we as of right now don't have any mandatory requirements when a case begins. I will get into that a little bit because beginning January, the Texas Rules of Civil Procedure have gotten a massive overhaul where there are going to be mandatory requirements to exchange basic information, finances, tax returns, also documents regarding real estate, bank statements, similar to that. So that is going to be a new addition to Texas Rules of Civil Procedure beginning January. But for me, most of my cases where I feel like we're concerned about money, which everyone is right now, I get that, I immediately try to reach out and see if we can exchange what we call in Texas a sworn inventory, which is just a list of all of your assets and debts so you can get a general idea of what property is at stake that needs to be divided. In addition, we do some supporting statements, whether it's 6 months to 2 years. We also want to exchange tax returns and basic financial information, maybe health insurance. I think that that's a great way to start a case, just to get that general information without having to do formal discovery.
Yeah. You know, early in my career, I did some federal work where jury trials, and there's different rules in the federal court system with regards to mandatory disclosure of expert witnesses and list of witnesses and what is expected or anticipated to be entered into evidence. Those are things that don't exist, particularly, at least in my state or in the states in which I practice. And that's why I always believe, and I want your opinion, Colleen, in terms of formal discovery, whether it's depositions, I'm a big fan of, or requests for admissions or subpoenas or interrogatories. These are things when I meet with a client, I say, look, I know this costs money, but you want me to do an effective job for you, and I can't go into a court. There's a lot of secrets as it is because we don't know exactly who they may or may not call. We know some of the evidence, but if we do all of these things, don't you agree, we're in a much better position to either evaluate the case, tell the client what they should be doing, or they should consider settlement, and then give them the best and the worst and the likely scenario in terms of what we think is going to happen by doing that discovery. Don't you agree?
Absolutely. And I do feel like there's, for me, some discovery that I will wait to do till later in the case for the hopes that maybe a case will settle. Again, not every case. Some cases you have to immediately out of the gate know that, all right, this is going to be contentious. We need to get maybe an opposing party to commit to her story in some way, which is my favorite is depositions. You want them to be deposed. You want them to be deposed right off the bat, before maybe their attorney knows what's going on and is able to coach their client into a reasonable explanation or story. So if you do a deposition at the very beginning of a case, they're tied to that answer, and it's going to be harder to try to manipulate it going forward. Same thing with a request for admissions, which are very underutilized because they can be complicated. Request for admissions is basically a statement where the other party has 30 days to admit or deny the statement. You have to be very straightforward with this statement, but when you know the elements that you're trying to prove, for instance, prove that a house was purchased prior to marriage, you ask, admit or deny this is the marriage date, admit or deny this house was purchased on X date. There, you have those elements already reached. So incredibly helpful when you're trying to go into court and you might have a difficult witness or opposing party. The other thing with the admissions, which is nice, especially if they're not represented, you have 30 days to respond. If you don't respond, it's an automatic admission. So kind of a civil procedure tool that can be used to your advantage.
Yeah, I think the request for admissions is an underutilized that, and opening statements. I've always talked about that. For everyone that watches trials on television, the make-believe ones, you see opening and closing statements, and some states don't allow it. They do here. I'm a huge fan. I was a prosecutor at one point. I did defense at one point. I did civil defense at one point. I'm a big fan of those utilization of the things that you wouldn't typically see in family law and take it to the next level. And to kind of wrap up your segment, Colleen, Talk real quickly, briefly about the changes in Texas, and I encourage guys, since this is just Texas related, but to really research and whether or not what the civil rules of procedure are, the available discovery tools and techniques, and talk to your lawyer about it, see if there are changes coming up in January, but what's going on in Texas in January?
Absolutely. So right now they have sent out proposed changes to the Texas Rules of Civil Procedure effective January 1st, 2021. And like I said, it's a massive overhaul where what I was talking about earlier is exchanging that basic information, which I like to do at the beginning of the case anyway, that basically that initial disclosures is what they're calling it, needs to be filed within 30 days after filing the answer unless an agreement is reached otherwise. So that means you want to produce bank statements, real estate documents for custody situations or anything regarding children. You're going to want pay information and health insurance. Additionally, we're going to have some changes to designating experts, which I think is going to be helpful just because it's going to add some details and closures to when those designations have to be done. And I think it gives more time prior to a final trial, which I think will help with settling cases, but getting that information really circulated.
Yeah. Thanks, Colleen. So Jessica, let me talk to you as we continue to roll into nearing our second half and remind everyone to submit their questions. We have a number of them coming in via the Q&A section. If you want some questions answered here in the second half as we get through this, we'll do that and submit those to our panel to the extent we have time. So Jessica, I want to talk a little bit about custody. You and I did a podcast a couple of weeks ago on this, and I think it was worthy of talking again about it. Guys have kids out there. They want to know what they should do. Being active participant, and as they prepare for divorce, whether they're before, we talk about being straightforward. Don't you agree? What should they be doing in terms of being straightforward?
Absolutely. I think that's it in itself. The first thing you want to do when you meet with your attorney is be completely upfront, straightforward about your situation and all aspects of it, the good, the bad, the ugly, the great. If we know from the offset, from the beginning of the case, what we're working with, it's going to help us as we prepare to support all of our requests and your interests, your desires, and what's best for your kids. One thing I was going to mention, Diana, about all the discovery and something that you had said too, Colleen and Scott, about just being prepared, and it's important, and it may be a little more costly. It may cost you extra to have us complete that discovery, but especially with children, it's going to be extremely important that we have all of our bases covered before we get to trial. And without some of those discovery requests of the other party, we may not have enough. And I know some of my clients in the past have been frustrated with the fact that the other side may not be complying with the requests or disclosing everything while on our side we are. And so I just wanted to make the point that even if the other side isn't complying with these rules, these court orders, it doesn't mean that we should take the position that we shouldn't. And that should give us even more reason to stay compliant so that when we do get to court, you can look like the one who is above board in every instance. And so being straightforward about where you are will help us draft those requests and figure out what we need to support your case best. Some important information that you also want to talk to your attorney about regarding the children. You want to have a list of the last 5 years where the children have lived, who they lived with. If you guys have been separated for a while or maybe never were married, we want to know whose house they were at and for how long. So also include any parenting time that you've had in the past or any schedules that you guys have worked out. Documentation that you want to gather would be any medical records. If you aren't going to doctor's visits or haven't in the past, start. They keep a record when you get there as who checked the child in. And so it's important if we gather medical records that you can show that you take the kid to the doctor. And I think that's something that we forget or don't think is very important, but judges and courts across the board see that as you are participating in the child's life, even if it means you have to miss work to do it, which is important to build your case. information about other cases that the child has maybe been involved in. For example, if child support has already been established, maybe parenting time, decision-making, custody issues haven't, but child support has, we need those documents. And it'll save you some money as well, the more that you can produce, so that your attorney doesn't spend any time going out and looking for it. Another thing too is that if you are paying child support or ordered to pay child support, are you current? And if you're not, what the balance is, and maybe discuss a plan on how we can get you caught up, or at least in compliance with your monthly obligation. And if a modification needs to take place, maybe that's where we start. And so that when we go into a custody request or battle, you'll be compliant at least on the child support end, which will also help your case. Incriminating evidence. I know Diana touched on it too, about it being extremely important that we gather the evidence to support your credibility and maybe even discredit opposing parties. So if like she said, if you have your children on the weekends and she says, oh, he's never had them overnight, but you have a text that shows, hey, I'll be there at 5 on Friday, and the next text is, what time are you coming to pick them up on Sunday? Then we can show that and produce that to the court and show that the other party isn't being honest, which will help moving forward, discrediting them in the beginning. And then any evidence related to drugs or alcohol charges on either side. So even if it's something that's not going to help your case, maybe you're the one with the background that may not be so positive, we still want that up front. We need it so that we are prepared moving forward, because the other side is going to bring it up. And also we can help you think of some ways to prepare for court. If it's a drug or an alcohol related issue, what classes have you taken? Have you taken any courses? Do you have any certificates that we can produce that show that although it maybe was an issue or is an issue, that you're doing something to shine the best light on your case before we get there.
You make a good point on that, Jessica. And that is, with alcohol and substance abuse, a lot of guys come in and they say, well, they feel like what they've done in the past, it's going to control their future. And I think, as you suggest, there is a way. And I think what judges are looking for is, what you've done in the past certainly is evidence, but what you're going to do moving forward is going to be reflective of what's going to happen. And so I think you make a great point by, there are classes, whether you go to AA, whether you go into some treatment or therapy, what you choose to do. Maybe we suggest, a regular routine schedule of drug and alcohol testing, whatever it may be. I know that we even talked about SoberLink earlier today. There are multiple things that we should be doing, but I think that's why we want to talk about it today. And that is, investigating your case, getting ready for your case, preparing. All is not lost. Don't let your future be dictated by your past. We've always talked about that. There's a way to kind of put yourself in that great position, and certain things you can do. Ask the attorney about that. Let's see if it's an appropriate thing for you. And so I guess, kind of thinking about all of these things, it is incumbent about making sure you choose the right lawyer. Isn't it someone who only practices exclusively family law? Yes, I think that's an imperative. I know before I joined Cordell Cordell, I worked for sort of a boutique firm where we had basically anybody who would walk in. We did civil litigation, bankruptcy, family, and the problem with that is you don't get an opportunity to specialize in anything when you're doing everything. And so I think what's really important is, as you interview, and I recommend interviewing your lawyer, go to consultations and figure out who best suits you and will best suit your case, that you really feel like you can connect to, that you can be open with, that you can talk to, and that has, like you said, Scott, a background in family law and exclusively practices in family law. The rules in the family law court are very different than the other courts, at least in Arizona, and I think that's the case across the board generally. And so you want someone who is in the family court day in and day out, knows the judges, knows opposing counsel, works with these people on a daily basis, and it's all they do.
And if Allison, I can just chime.
Go ahead.
chime in with that, Scott. So for example, I mean, obviously knowing the judges and knowing the rules is very important, but just like Jessica said, so I was working at a boutique firm. I knew the rules, I knew the judges, but it's not like practicing day in and day out. We also know the experts. We can recommend people. For example, I have a case pending right now where mom basically alleged everything under the sun. So psychosexual, alcohol, custody. So I was able to, because I've used these experts before, recommend a psychosexual evaluator, recommend a custody expert, recommend things that so he can come. And we went from 0 visits, everything was supposed to be supervised, to this crazy sexual deviant where I have 4 different experts now saying there's nothing wrong with dad, give him joint legal and residential custody, and the judge is basically there, just because we knew which experts to be able to choose.
So I think it's a good point. I mean, I think when I did some federal practice, the judges kind of knew who you were. They didn't really particularly know your practice style. They didn't see you a lot because federal practice is a little bit slower in terms of getting to trial. And I think it's one of the things that I liked in terms of family law is the judges know you by name. They know your practice style. They know your firm. They know your reputation. Not that that's going to influence their decision, but it certainly gives credence to the presentation that you give. And when you do present cogent, clear, and arguments that are backed up by case law and statute, they're going to, they understand that you're not just, blowing smoke. So I think it's a good point. Allison, kind of as we round out and we want to get to the question and answer section, we have a number of questions, obviously. It's preparation. Maybe you can talk to guys here about preparation and why it's important and when they should start.
Well, I mean, I think the first thing is that it's never too early to start. I mean, realistically, we're starting with our initial filing. We're starting with that initial consultation even before the divorce is filed. So get started early and start working with your attorney right away. I tell my clients all the time, you do not win the day of the hearing or the day of trial. You win by preparing and laying all the groundwork so that you're ready to walk into that courtroom. So the first part is really start preparing with your attorney. Think about what potential evidence, what potential witnesses you might want to call for a particular hearing or trial, and talk to your client or your attorney about your ideas. So provide possible exhibits to your attorney. So if you think a document may be relevant, provide it to your attorney so they can start looking at it. Talk to them about people that may have witnessed something or that you think may be helpful to your case. It's better to give more information and we can narrow it down together than to give less information. Also, an important thing to think about are, do we need expert witnesses of any kind? Do we need somebody to help us come in and educate the judge? Keeping in mind, judges are not experts. They do not know all the particular areas of finance or, psychological issues. So figuring out, do we need to tell the judge something, and can an expert do that in addition to our party testimony?
So let me ask you real quickly, Allison, because as we get closer to the second half, as we think about discovery and experts, you mentioned that that's a key. And I think that, again, similar to the request for admissions, I'm a big fan of a utilization of an expert because you get into a he said, she said. I was just sitting through a conference with judges and we talked about experts. And it is interesting because they must have some sort of independent facts and testimony in certain circumstances, whether it's valuation of businesses, whether it's custody, because what are they supposed to do? They have to go to a he said, she said, and especially when you represent guys, the scales are maybe tilted a little bit towards mom, and so you need some sort of independent evidence. Experts, what kind of experts do you suggest that are out there that you've used before?
Oh, well, there's so many different types that you may want to use. In particular, forensic accountants, business evaluators can give us values for specific businesses. You can get property appraisers. You can do a forensic accountant that would calculate need for alimony, determine what somebody's ability to pay is, determine business income. You could do some kind of psychological expert to come in and testify as to issues regarding children. You can do custody investigators, people that will go in and actually see what a child's life is like, see who's interacting with the child, see what's going on in school, and then they can make a report and recommendation to the judge. So there's a lot of different types and options. They may not all financially be feasible, but figuring out if they're going to benefit your case in a way is very important to do from the start.
Yeah. And in terms of some of the things I said, that at family law sometimes is plagued by the lack of preparation. I can tell you in the number of years that I've had attorneys on the other side walk in, and I am confident they have not met with their client before the trial. They did not go through the expected questions or their answers. And would you suggest that in preparation for testimonial hearings, whether they're just interim motions, orders of protection, or the ultimate trial, not memorizing the answers and not sounding scripted, right?
Absolutely not. I specifically do not want to provide my clients with my list of line of questioning for them, because I don't want them to get in a pattern where they're nervous and they try to memorize an answer. It's more important for them to have a conversation with the judge and tell the judge what's going on than to have some kind of scripted answer that sounds rehearsed.
Yeah. And, I've said before, representing guys, it's about appearance, how do they look, and presentation. And, it's okay to be nervous. And I tell my clients, look, I get it. You have a lot on the line, but if you're genuine and you're telling the truth, then that'll come through. And so again, poker face and how they, what they should wear, that's important as well.
Mm-hmm. Absolutely. It's your presentation, right? It's the judge is making an impression from the second before the hearing starts. I mean, whether it's an in-person hearing, a Zoom hearing, they're paying attention. They're watching everybody. So if you sit down on a Zoom hearing before they start talking, what is your reaction? If your former wife is testifying and you have faces that are going on, they're noticing those types of things. So how you dress, how you're behaving, all of that is important.
So I imagine you'd recommend, like I would, before a trial, you have at least a meeting with your attorney. Obviously, COVID's complicated things, so sometimes we may be doing this via Zoom as opposed to pre-COVID, where we would have them in the office and an in-person discussion. And would you go through potential expected questions and go through exhibits and make sure they're familiar with them before they actually get to court?
Absolutely. So I think that it is essential to have at least a couple prep meetings with your attorney, and that's for your benefit. So the first one is just talking about overall strategy. That can be part of other conversations, but that's important to start from the get-go. Going through, what is our presentation story? What is our evidence? Who are our witnesses? What is the procedural order? As in, am I going to do an opening? Here's my opening, and who are we calling, and what order are people being called? When am I, as the client, expected to speak? But then prior to and right before any hearing, you want to do an actual run through of your line of questioning with your attorney. So basically, in a general case, you're going to be called for two different things as the party. You're going to be called for a direct with your attorney, and then the other side is going to have the opportunity to cross-examine you. So really, we want to do both of those things. I have my line of questioning. I have all the exhibits. I'm going to go through all of that with you in detail. We're going to have a conversation, make sure there's nothing we need to tweak or clarify, make it sound as good as possible, but also make you comfortable with it. And the other thing that I really encourage is we do a mock cross-examination. Pull another attorney from our office and have them just do a cross-examination to help you get comfortable with that aspect. That usually is the thing that makes the people most uncomfortable. There are going to be points in any cross-examination, but we're able to prepare you for that.
Yeah. And I think kind of wrap it up and then we can get right into our question and answer session is never guess. And, if you're a guy watching right now and your attorney hasn't told you this, don't guess on the stand, right?
Absolutely not. Never guess. Don't assume anything. You can't make any presumptions. Realistically, if you don't know, you just say that. That's okay. You're not meant to memorize everything. You're not meant to be 100% on everything. But just you want to be clear so your testimony does not somehow get skewed.
Yeah. All right, so don't forget, like right now, we'll get to the question and answer session. If you have a question, you haven't yet submitted it. We have a number of them right now. Submit it via the Q&A section. Give us your first name and the state. We'll get to that, and we're going to toss it to our panel of attorneys as we spend the last 15 minutes going through some of the questions that we have. So this one comes from Florida. So Allie, we're going to come right back to you. Two-part question, actually. Teresa says his attorney, it's her son, she's asking for her son, will not respond to his questions. I understand the office may be closed, but surely they can answer virtually. Are the courts there to back it up? Are they back up and running? Are they closed? Maybe let's talk about two things. One, what's the status of the court system? And two, we can reflect on what our policy is in terms of responding and what maybe Teresa's son should be doing.
Okay, well, first of all, in Florida, we are open, but it is by virtual hearing. So I'm not aware of any counties in Florida that are doing in-person hearings for family law right now. I know that some other areas of law are doing in-person hearings, but not family law. So we are doing all virtual hearings, and it's actually been going very well for us. We have not stopped. Cases are still moving forward. Judges are still there, judicial assistants, but everybody's working remotely. So your case is absolutely open, and we're moving forward. So that should not hinder your case. As far as your attorney's communication, certainly we can't speak to another attorney, but our policy as a firm is that we're going to respond by the end of the day. If it's a business day, if you leave a voicemail, if you send us an email, we're going to respond to you that day. And if, let's say, the attorney's stuck in another hearing or something, we're going to make sure somebody else in that office gets you an answer, either another attorney or one of our assistants, at least, to make sure that you're being addressed right away. So if you're not able to get in touch with your attorney, that's something to consider.
So just one more follow-up, Allison. Teresa has another son, has a question regarding child support. Obviously seems to be COVID related because he's an airline pilot and he's on voluntary leave, or the airline has put him on leave until the end of December. His ex-wife has a full-time job with benefits. What should he be doing to try to get some child support relief? Because soon he'll have no income coming in at all. And job prospects for pilots, as we all know, are not good, especially today. I just saw some earnings reports. Delta posted record $5 billion in losses. So what should Teresa be telling her son in terms of getting some available relief?
Well, the first thing is, let's start right now, even if he has some available income right now. Let's get started. There's basically two options. We could do a temporary hold on his child support obligation, or we can actually do an outright modification to get a reduction. And it just depends on the specific circumstances there. If he expects to go back with the same salary, it may be a temporary thing. But if we need to modify, let's go ahead and do it. And the reason I say that is because judges can only go back to the date you file for that relief. So it's essential that we get it filed with the court. Even if the judge can't hear us for a little while, at least we have preserved that date of filing, and the judge can retroactively apply it back to them.
Yep. All right, Colleen, let me go to you in Texas. The question really has to do with kind of the lack of objectivity when it relates to moms and dads. You know, I've talked about this quite a bit in terms of, you know, we think of Lady Justice as a blindfold on, and you know, I was asked in the Wall Street Journal many years ago if I could change the, you know, the process or the law as it relates to family law, what would I do? And I said, well, you know, petitioners and respondents would be petitioner A, petitioner B, and you wouldn't know what role they played, you know, whether they were the primary parent or the secondary parent, or they were a man or a woman or whatever it may be. And this really is the question coming from Texas, and that is, what do you do when you know you have a judge that the super majority of the time, historically, they give custody to moms and they don't believe in a 50-50? How do you approach that?
Yeah, Scott. So the first unfortunate hurdle that we're up against is in Texas, we have the Texas Family Code, which every state has their own code of what is the presumption. In Texas, we unfortunately, the presumption off the bat is a standard possession order instead of a 50-50 possession, which is just unfortunate. Every year, we do try to work with changing that law. We work to try to change the presumption to be a 50-50. So that is what it is. That's what it's supposed to be going in. So parents do have equal access, and then it would be the other way around, proving that less possession is maybe where it needs to be. Under the Texas Family Code, it 100% says that you're not supposed to consider gender when determining this, but that is a hurdle that you get in front of a judge. Something that worked effectively on a last trial of mine is we created a big mock exhibit of parent A, parent B, and put in all of the information, and very much continue to try to get gender out of it, gender out of it, gender out of it. I think just focusing on, as much as possible, proving the points of your case, and knowing that you're dealing with a judge that might have that situation and might maybe make or rule towards mom sometimes. But even those judges that I'm in front of now, sometimes they do lean that way, but I've seen them switch. You know, there are situations where 100% what's in the best interest of the child, that's what's most important.
Yeah.
So.
I mean, it's, you know, if you look, I've always said, unapologetically step on toes. And that's what you really have to do. And sometimes, you know, I'm borderline being held in contempt. I remember a judge, I had represented the guy in order of protection, and he was assaulted and broke both orbital sockets, and she used a frying pan. And so we filed an order of protection. We go in and argue before the judge, and the judge looked at me and said, "Why doesn't your guy just fight back or walk away?" And I said, "Look, she put him in the hospital." And I said, "If I represented the woman, you would not even question it. In fact, you'd probably make sure that the prosecutor pressed criminal charges." And I went on and on. And the judge kind of sat back, and I thought, "Oh, here we go. I'm going to jail." But he said, "You know what? You're right. I shouldn't have looked at their sex and determined, and as a predicate to my decision." And so sometimes you've got to make sure you have an attorney who will press back. Sometimes it works, sometimes it doesn't, right?
And it's really important to press back, not just when you get in front of a judge, when you're dealing with those experts prior to, let's say, a guardian ad litem or a psychologist or a therapist that's been appointed in this case, and we're having those conversations ahead of time, and they're saying something to me, and I hear myself, I feel like once a day saying, if the genders were reversed, would this still be a problem? Or if the genders were reversed, why aren't we doing something about this? So with Cordell and Cordell, that's what we work with, right? I mean, we know that that's the hurdles that we have every day. We have that experience. We know it's not something that we have to remind ourselves to focus on. That's always in front of our heads of making sure that that is something that we overcome, unfortunately.
Diana, a question came in. And the question really is about, can we help someone either draft a separation agreement to try to get it resolved? They're separated on the same roof until their high school junior graduates. Then they'll file for divorce. And the question really, I guess, is, we'd say we're a domestic litigation firm, and I'll answer as well, but can we help just prepare a separation agreement?
Absolutely. I have several cases where that's exactly what I'm doing. And instead of a prenuptial agreement, we generally would call it a postnuptial or a separation agreement. And it just encompasses all the terms of what would happen in the event of a divorce or when you both are ready to separate, but it's amicable right now. So it's actually the best time to do it. But absolutely, I have several cases right now where that's exactly what I've done for the client.
Yeah. And I think it's truly one of those things. I'm a big fan of. We talk about mediation, but I talk about informal. And that is, I'm dealing with the case right now. I said, let's come in, let's go ahead and file. But at the same time that we file, let's prepare a separation agreement. Let's give it to your spouse, and let's try to head off all these fees and see if they'll be reasonable and resolve this. And that's certainly an approach that I think every case can take, but it's an option that should be presented to the client. So Jessica, I have a question. It comes from, what are the implications of a life insurance policy in place at the time of filing? So this person's paying for the life insurance. They don't think their spouse should have any part of it, and they want to know if they can change the beneficiary. And I know, and I'll mention here in Missouri before you answer, there's some standing orders. At the time of filing, you really can't make any changes like that. You can't make health insurance changes. You can't sell assets. You can't change beneficiaries without leave of court. And so what's going on with you in Arizona, and what do you think?
Sure, yeah, and it's a great question. We get it all the time, especially if the person is the beneficiary and has threatened your life throughout the litigation process. Part of it is, in part, we have the same thing. It's called a preliminary injunction. And so when at the time you're served with the divorce paperwork, you're also served with the preliminary injunction, which prohibits both parties from selling, transferring, concealing, otherwise disposing of property. And in Arizona, we're a community property state. Life insurance policies are considered community in nature. If there's a cash out benefit or option, and I'm not sure in your case in particular, but if there is, then she is entitled to whatever it may be, half of whatever it may be. And so what the court does is they take the position that you can't make any changes throughout this process, unless you receive relief from the court. So the court allows you, or by mutual agreement. So you and her can both agree. Maybe you want to change it to one of the adult children, or if she has a policy and she wants you guys mutually agree that she changes her beneficiary, you change yours. You can agree outside of the court as long as it's in writing and signed by the parties. And I would recommend you talking to your attorney, going through hers if she has one, to make sure that it's done properly.
And there's always an asset trade-off. It doesn't mean that, when we say she's entitled to half or a portion, and we can trade assets for it. And so I
Absolutely.
think this is a conversation again. Let's put all the assets on a piece of paper. Let's figure out where it goes.
That's
So
right.
next question, Allison. Tom has a very large gun and knife collection. Half of those are designated for the kids when they become of age. And the question really becomes is, should Tom be worried about wife coming after them? She has a collection as well of silver coins that he doesn't really want, but I guess he's really concerned about the guns and knives that he's really designated for his kids.
Well, I mean, it's one thing to say it may be something that comes into account as an asset division, as in the value of it is relevant. If it's something that is historically his, he's done all the work, it's his collection, then traditionally, in Florida at least, we wouldn't traditionally see a judge awarding that to the other side. But you want to reasonably value it when he's presenting the values or his proposed values. Make that reasonable. Let's not say they're worth $1 if we know they're not. Let's make it a reasonable amount, because the one time I have seen judges kind of flip it and say, okay, the other side's going to keep it, is if somebody says, no, that's not worth anything. And so the judge says, okay, well, it's not worth anything. I'll give it to your wife. So you just want to make sure that you're presenting it accurately, you're accounting for it. One recommendation I would say is definitely write everything down, have it in a safe place, just so you have a listing and an inventory of what you know exists, so that when it comes up later, we can account for it properly.
Yep. Diana, David has a question. It says it's a unique situation. Empty nest, no minor kids at home, fairly significant assets. Have the options to file in Minnesota or Texas. And I'll actually ask Colleen to chime in as well. But Diana, you first. How can I get an assessment as to what state of filing would be better to preserve the assets for myself?
Actually my favorite part of this firm. So the fact that we have so many different offices, I mean, we get that all the time, actually. So for example, New Jersey, New York, they could be 10 minutes away. And a client says, well, I've lived in New Jersey for a year. She's lived in New York for a year. How do I know? Obviously, somebody like me could answer both questions, but if it's somewhere that's further, like Minnesota and Texas, you'll call our Minnesota office, you'll do a 1-hour consult, you'll ask them all the questions, and then you'll do an hour consult with the Texas office and you'll ask them exactly the same questions, and you'll weigh the pros and cons. And certainly at that point, the attorneys can also speak with each other, the Texas attorney and the Minnesota attorney in our office, and tell you what the best option for filing and with respect to, I mean, if kids were an issue, which I know in your case it's not, but with all of your assets, why would it make sense to file in Minnesota, or why it would make sense to just file in Texas?
Mm-hmm. Same thing, Colleen?
I agree completely. And then the other aspect of that, don't wait. Go talk to them right now, because if she files, if both Texas and Minnesota have jurisdiction, which is quite possible, it really comes down to is who files first. So you want to make sure that you're getting the information and you're filing regarding what state is best for you. And I will say, I know some about New York law. I'm not familiar with Minnesota, but the Texas laws regarding spousal support here are amazing compared to New York, New Jersey. And so something like that, just call and get that information. It really could save your case.
Yeah. And I think it's important. I like the jurisdictional issues. I have an appellate case that kind of sets some law in the area as it related to child support between Missouri and Oklahoma. It is the wonderful thing, as you all have pointed out, that we'll send out an email and we've got 300 lawyers and we all provide input on that. But you get a Texas lawyer and a Minnesota lawyer up in our Edina office on the phone. Let's look at maintenance. What's the we know Texas or Kansas has a very different law than Missouri does as it relates to alimony, spousal support. That could be an issue. We want to make sure and give the opportunity for the client to file where they need to. So that's important. Let me turn to Jessica. This is a question from Illinois. Is it Yaren, I think, was the primary caregiver for a 5-year-old until my wife moved out. Wife took him and filed an emergency order of protection against him. Got an ex parte. It was vacated 1 week later. The judge determined that the status quo was the situation that had resulted from the order, not prior to the order. The question really from Yaren is, he's getting only 5 out of 14 overnights. How can Yaren get more? Obviously, this is Illinois, but in Arizona, how could they get more?
Sure. So part of that is, I believe it sounds like it's still in the temporary order stages, maybe not final orders yet. So if you haven't got to your final orders, the best thing you can do before your final orders is to request as much time as possible from mom. So do your best to start redeveloping a relationship again if it's been broken, or at least just cordial conversations. Anytime, any more time you can get will help you. So if you ask her, even though it's not your night, hey, I really want to take the kids to the park this evening, and can they stay the night? And if she says no, fine, document it. Do that once a week, as often as possible. And then the times that she says yes, take advantage of it. And if you want to give her more time to think about it, say, hey, how about this weekend? Do you mind if they come over? This weekend I'm having so-and-so over, their cousins or friends or whatever. Try to develop as many opportunities as possible to see them as much as possible. And then you can document it and show the court that there's no reason that the children shouldn't be with you. And if at the end of the day, she never lets them come over, then you have all this documentation that you are asking, you are requesting. And then also gather as much information you can. You said you used to be the primary care provider, the caregiver. To find witnesses, text messages, emails, Facebook, pictures, anything you can do. If they're in school, get school records that you were the one pick up and drop off. Talk to neighbors, see if they'll testify. Just to develop your story, evidence and proof that you were the person who did it before, and it should be restored that way.
Yeah, taking action, not waiting, jumping on it, filing for divorce, filing for custody action, doing something that's the last thing a judge wants to see is someone sitting on their rights, not taking action, especially when they feel they are aggrieved or that they need more. Consult with an attorney right now. So that's all the time we have for the lightning round. I know there were a number of questions we didn't get to, but we'll try to get to those in our weekly podcast. If you have other questions that you want answered, submit those to coronavirus.divorce@cordelllaw.com. You can find us on the web at cordellcordell.com, as well as social media. Continue to tune into our weekly podcast. You can see that on our YouTube page, as well as going to cordellcordell.com. If you want to schedule a consultation, we mentioned that earlier on. It's important to just get some information. You can contact us at 866-DADS-LAW. Looking forward to the next virtual town hall coming up in November. Go ahead and register for that. We'll again bring you some more information for guys as it relates to divorce and all things before, during, and after. Until next time, have a great week.